What if one simple call recording could win your case? Or completely destroy it? Many people believe recording a call is enough, but in law, that is only half the truth. The Supreme Court has laid down strict conditions, and if you miss even one, your evidence can be rejected. So before you rely on any call recording, let's understand the exact legal rules that can decide your case. Introduction. Friends, welcome to my YouTube channel Legal Information Law Insights. I am Advocate Mukund Mahajan. I am pleased to share that our channel has crossed 1 lakh subscribers and received the YouTube Silver Creator Award. You may also support the channel by becoming a member with a contribution of 59 rupees or 119 rupees via the GPay QR code shown on your screen. Thank you for your continued trust and support. Now, let us move to today's topic. In the previous video number 97, we discussed whether call recording is legal in India and how the right to privacy applies. Now, let us move one step ahead and answer the most crucial question: can a call recording be used as valid evidence in court, and what are the legal conditions for it? Part 1: Right to privacy. To understand the legality of call recording, we must begin with the landmark judgment of Justice K.S. Puttaswamy v. Union of India. Case snapshot. Case number, Writ Petition, Civil, number 494 of 2012. Decided on 24 August 2017. Court, Supreme Court of India. Bench, 9-judge Constitution Bench. Parties to the suit: Petitioner Justice K.S. Puttaswamy, retired, and another. Respondent Union of India and others. In this historic case, the Supreme Court examined whether the right to privacy is a fundamental right under the Constitution of India, in the context of the Aadhaar scheme and collection of personal data. The court clearly held that privacy is a fundamental right under Article 21, read with Articles 14 and 19. The court further explained that privacy includes personal autonomy, bodily integrity, and informational privacy. Call recordings fall within the scope of informational privacy, meaning such recordings must respect dignity and freedom of choice. Legally precise position. If a person is himself a party to the conversation, recording that conversation is generally permissible, provided it does not violate any statutory provision, involve illegal interception, or infringe reasonable expectations of privacy in the given facts. On the other hand, unauthorized interception, hacking, or third-party surveillance may violate statutory provisions such as the Telegraph Act and the Information Technology Act, apart from constituting a breach of privacy. It is also important to understand that the right to privacy is not absolute. It is subject to valid law, legitimate state interest, and the test of proportionality. Part 2: Electronic evidence. Now let us move to the second crucial aspect: admissibility of call recordings as evidence. For this, we refer to the Supreme Court judgment in Arjun Panditrao Khotkar v. Kailash Kushanrao Gorantyal. Case snapshot. Case number, Civil Appeal number 20825 to 20826 of 2017. Decided on 14 July 2020. Court, Supreme Court of India. Bench, 3-judge bench. Parties: Appellant Arjun Panditrao Khotkar. Respondent Kailash Kushanrao Gorantyal and others. In this case, the court dealt with the admissibility of electronic evidence and clarified whether a certificate is mandatory. The Supreme Court held that the requirement of a certificate is mandatory when an electronic record is produced as secondary evidence. This means that if you are presenting a call recording through a copy, CD, or digital file, you must comply with the certificate requirement. However, if the original device itself is produced in court and properly proved, the certificate may not be required, subject to proof of authenticity and satisfaction of the court regarding the integrity of the device and recording. Practical caution. Courts may still insist on foundational evidence to establish authenticity and reliability, even where the original device is produced. The certificate must contain details of the device, the manner in which the record was produced, and a declaration regarding its authenticity. The court also clarified the legal position by following the earlier judgment in Anwar PVV PK Bashir and overruling the contrary view taken in Shafi Muhammad. Additionally, if a party does not have access to the device, they can approach the court to direct the concerned authority to produce the required certificate. This judgment has wide applicability in criminal trials, civil disputes, and election petitions. Without compliance, there is a risk of rejection of evidence, whereas proper compliance can make the evidence very strong. Practical Supreme Court illustration. To understand how courts deal with recorded conversations, we can look at the case of R.M. Malkani vs. State of Maharashtra. Case snapshot. Case number, Criminal Appeal number 172 of 1968. Decided on 24 September 1972, reported in AIR 1973 SC 157. Court, Supreme Court of India. Parties. Appellant, R.M. Malkani. Respondent, State of Maharashtra. In this case, a doctor was accused of demanding a bribe, and the complainant secretly recorded the telephone conversation. The Supreme Court held that such recording is admissible, provided it is relevant and its authenticity is proved. Refined legal principle. Illegality in the method of obtaining evidence does not automatically make it inadmissible, unless there is a specific statutory or constitutional bar. However, courts may exclude such evidence based on fairness, reliability, or violation of rights. In today's legal framework, such recordings must also satisfy the certificate requirement under Section 63 of the Bharatiya Sakshya Adhiniyam and comply with privacy principles laid down in the Puttaswamy judgment. Part 3 Law Update in the year 2023. A very important development is the enactment of the Bharatiya Sakshya Adhiniyam, 2023, which has replaced the Indian Evidence Act, 1872. Legally precise clarification. Section 63 of the Bharatiya Sakshya Adhiniyam substantially corresponds to the earlier Section 65B of the Indian Evidence Act regarding electronic evidence. The core principle regarding electronic records and the requirement of a certificate continues. It is also important to note that earlier Supreme Court judgments continue to hold value to the extent they are consistent with the new statute. In practical terms, Section 63 of the Bharatiya Sakshya Adhiniyam applies to electronic evidence, including call recordings. Final summary. To summarize, there are 3 essential steps. Step 1. Privacy check. Ensure that the recording does not violate fundamental rights. Step 2. Evidence check. Comply with the certificate requirement in most cases. Step 3. Apply new law. Follow Section 63 of the Bharatiya Sakshya Adhiniyam. Golden Rule. The Golden Rule is simple but very important. Call recording by a participant is generally permissible. But legality depends on facts, intention, and method of recording. Admissibility depends on compliance with procedural law. Courts will examine relevance, authenticity, and reliability before accepting it. Misuse may attract civil or criminal liability. Thanks for watching this video. If you found it informative, please like, freely subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind!